My name is Shayana Kadidal, and I'm counsel in the Humanitarian Law Project case for the plaintiffs. Here at CCR, I'm also the senior managing attorney of the Guantanamo Project at the center, and I've been here for about 8 years. This case has actually been going on for about 12 years, and it's essentially a straightforward challenge to the material support statute, which is a criminal law that was created basically in 1996. And the way it works is this. The State Department creates a list of designated foreign terrorist organizations. Once a foreign organization is on that list, almost any form of association with that organization becomes a very serious crime, subjecting you to up to 15 years in prison. So it's not just things like giving arms or money to the groups that are on this list, which are the kind of things that people usually think about when they hear the term material support, but it's also providing training or expert advice or assistance, or providing yourself as personnel or your services. So our plaintiffs in this case are basically humanitarian groups. On the one side is Dr. Ralph Fertig and Humanitarian Law Project. These are folks who specialize in doing nonviolent dispute resolution, and what they like to do is go into conflict areas and talk to warring parties about how to reach nonviolent conclusions to their conflicts, how to pursue their political aims through nonviolent means, and also do things like go and talk about human rights monitoring or help groups present human rights claims to the United Nations or other intergovernmental bodies. So Humanitarian Law Project wants to do this in relation to the Kurdistan Workers' Party, the PKK, which is a group that our government has put on the designated foreign terrorist organization list. So they can't go and do those things, giving human rights training, trying to create nonviolent alternatives to the conflict, because they're prohibited from doing so by the material support statute. It would be providing training or providing themselves as personnel or services and so forth. The other plaintiffs are a number of groups of Tamil humanitarian organizations here in the United States. A lot of the members are physicians, and they're Tamils from Sri Lanka. And for a long time, until very recently, most of the Tamil-speaking part of Sri Lanka was controlled by a rebel group, the Liberation Tigers of Tamil Eelam, or LTTE. Now, the LTTE was also on this list of designated foreign terrorist organizations, but they happened to be essentially the functioning government in a large area of Sri Lanka that was ravaged by the civil war, and then, because it lay along the east coast of the island, was also devastated by the December 26, 2004 tsunami. And so these groups, the physicians wanted to go and do medical assistance in the same way that lots of US surgeons went to Haiti. They wanted to help rebuild infrastructure. They also wanted to help with peace negotiations and to help around the negotiations for getting international aid into these areas after the tsunami. And they couldn't do any of it, again, because they would have been subject to criminal sanctions under the material support statute for doing so. So we challenged both the prohibitions on giving humanitarian aid and the prohibitions on speech, on things like training, on things like doing political advocacy, things like writing op-eds in newspapers and so forth, in the lower courts. But at the Supreme Court, it's only the speech, the pure political speech, that's at issue. The government really hasn't done a very good job of clarifying how much kind of association or coordination you can have when you're engaging in this political speech with members of these banned organizations. And so we think that presents very serious First Amendment concerns, and the lower courts have agreed with us. This case has been heard 3 times by the District Court in Los Angeles and 3 times by the Court of Appeals in the Ninth Circuit, and all of the judges have agreed with us that the statute presents kind of insuperable vagueness problems, that the terms are too open-ended and blurry and sort of step on areas that are clearly protected by the First Amendment in a way that ordinary citizens can't really tell what's prohibited and what isn't. It could be, the case that you want to support the lawful ends of the group, as some of our plaintiffs do, but that doesn't make a difference according to the government, and that's one of the things we're arguing for at the Supreme Court. That idea that the government ought not to be allowed to hold someone criminally liable unless that person intended to further the unlawful ends of the organization they were associated with, that comes out of a line of cases reaching back all the way to the 1930s, but primarily in the 50s and 60s, involving Communist Party membership. And these cases, the primary one is United States versus Scales, basically stood for the principle that it was okay to be a member of the Communist Party as long as you didn't intend to further the illegal ends of the Communist Party. And when you think about that, it's really a sort of extraordinary line of rulings, right? The court found, or the government, alleged in those cases, that the Communist Party was an international conspiracy, that it had sleeper cells planted in the United States, that it was involved in terrorism, and in most ways, that one can imagine, it posed much more of an existential threat to the United States than the threat of terrorism that we're facing now does. And yet the Supreme Court decided that it had to draw these limits, that you couldn't hold people criminally responsible for all of the bad things that the Communist Party did just because they chose to associate with it in ways that were lawful and peaceful. The fundamental problem with any vague statute is that it gives government officials too much discretion to decide who to prosecute, and it allows them to use that in kind of a politically biased way, that decision to prosecute some and not others. We hope that the Supreme Court, which is going to hear the case on February 23rd, is going to agree with the lower courts, and that they might even rule even more broadly and say that when Congress creates a statute like this, it can't make a person liable for the criminal acts of others, say other people who are involved with these organizations. And our plaintiffs are only seeking to engage in speech that furthers lawful nonviolent conduct, and I think the Supreme Court has never held that the government can prohibit that kind of speech from taking place. The case is only about speech, and I think there are a lot of things that people who are concerned about these issues can do politically to try to help ameliorate some of the other problems, the fact that the statute bans humanitarian aid. Right now, there are only 2 exemptions in the statute, one for medicines, meaning not even medical services, but just physically medicines, and another for religious materials. And we think Congress ought to expand on those exemptions greatly to basically exempt a whole variety of humanitarian aid. When you have a situation like that tsunami that devastated the east coast of Sri Lanka, it's really tragic that a statute like this ought to stand in the way of relief getting to an area.